Hello, my name is Kellie Joyce. I am a partner at Secrest, Wardle, and I am going to be talking about the use of statutory immunity in defending ski area claims today. This presentation is going to address several different portions of the Ski Area Safety Act, which is an acronym. There is an acronym for it, SASA, S-A-S-A. It is the acronym for the Ski Area Safety Act. During the presentation, you may hear me refer to the Ski Area Safety Act as SASA, which is just the acronym. This presentation addresses the definition and scope of the Act, the immunity provision in the Act, and its application to hazards that are identified within the Act. We will be talking about the applicability of immunity to hazards that are not identified in the statute, the application of immunity to chairlift injuries, the trouble with tubes, as tubes is not covered by the Ski Area Safety Act, and we will also talk about the use of waivers. Before we get started in talking about the Ski Area Safety Act, there are definitions that I want to talk to you about that are covered within the SASA. The first definition is operator. An operator is a person who owns or controls or who has operational responsibility for a ski area or ski lift. An operator includes the state or a political subdivision of the state. The next definition that I want to talk about with you is ski area. A ski area is an area that is used for skiing and served by one or more ski lifts. It's important that part of that definition, although it's not specifically set forth, ski area also includes areas that are used for snowboarding. It does not include areas for tubing. The next definition is skier, and a skier is a person wearing skis or using some sort of a device that attaches to at least 1 foot or the lower torso for purposes of sliding on a slope. So as you can see from the definition of skier, not only would skier be included in the definition, but also a snowboarder is included in the definition because snowboards strap onto your feet. Interestingly, the definition of a skier also includes a person not wearing skis or a skiing device while the person is in an area designated for skiing for the purposes of skiing. So this would include someone who had been in the warming house and now is going back out to the ski slopes and is walking out to the ski slopes to put on their skis for the purpose of skiing. It may also include a parent who is assisting a child in putting on their skis, and then the parent would have the intention of putting on the parent's skis to go skiing with the child. So just because the person does not have something strapped onto their feet doesn't mean that they wouldn't be included in the definition of skier in this case. Some important notes that I would like to talk to you about from the definitions section. A ski area must contain a ski lift in order to qualify. If it is just a hill and there's no ski lift or a tow rope, it does not qualify. The definition of a skier, as I discussed on the last slide, includes snowboarders. Anyone riding on a lift or tow rope would be considered a participant under the Ski Area Safety Act. And finally, ski areas must comply with minimum safety requirements to earn the protection of the Act. Minimum safety requirements that a ski area must comply with would include signage and licensure requirements. We will later visit a checklist that we are going to be talking about that has to be followed by the ski area in order to be protected and in order to gain immunity under the Ski Area Safety Act. Under the MCL section 408.342 subsection 1, the Ski Area Safety Act outlines a skier's responsibility. Essentially, while in a ski area, each skier must do all of the following. First, they must maintain reasonable control of his or her speed and course at all times. Second, they must stay clear of snow grooming vehicles and equipment in the ski area. They must heed all posted signs and warnings. And finally, they must ski only in ski areas which are marked as open for skiing on the trail sign described in section 6A subsection E. If the skier does not follow these rules, it would hurt the skier's claim in making a claim against the ski area if that skier were injured. From a defense perspective, in defending the ski area would argue comparative negligence on the part of the skier who was injured. So the Ski Area Safety Act has an immunity provision, and in the Ski Area Safety Act, there are hazards that are expressly identified in the statute, and those hazards are expressly identified, and then there are some hazards that obviously the legislature could not possibly think of every situation that could arise, and so there are some hazards that may come up that are not expressly identified in the statute, and we're going to talk about those in a little bit. For right now, I want to talk about the application of the SASA immunity provision for hazards that are expressly identified in the statute. This is found under MCL 408.342, Section 2. Each person who participates in the sport of skiing accepts the dangers that inhere in that sport insofar as the dangers are obvious and necessary. Those dangers include injuries that can result from variation in terrain, surface or subsurface snow or ice conditions, bare spots, rocks, trees, and other forms of natural growth or debris, collisions with ski lift towers and their components, collisions with other skiers, or with properly marked or plainly visible snowmaking or snow grooming equipment. Normally, if something is not set forth specifically in the Ski Area Safety Act, that is usually when the court has to get involved, and that's how we get our case law. And there are some cases that are on point that specifically address a situation when something is not specifically stated in the act. So what happens when something is identified in the statute and it is not being used for the purpose it is intended and causes injury? There's a case, McGoldrick versus Holiday Amusements, Inc. It is a 2000 case. In that case, the act essentially codifies the assumption of risk defense. In McGoldrick, the hazard was ID'd, which basically the hazard was identified in the statute, but it was not being used for the purpose under the act. And in this case, in McGoldrick, the plaintiff struck a pole that was used for a chairlift while skiing. So a chairlift is identified in the statute, but obviously the skier ran into the pole, which is not used for the purpose under the act. And since it was identified in the act, though, the court in McGoldrick granted immunity. The defendant was dismissed from the lawsuit in a motion for summary disposition, and the plaintiff received no money from the defendant in that case. And specifically, the court said that the clear language of SASA establishes that plaintiff's injury comes within the immunity provisions. The statute plainly states that a collision with ski lift towers and their components comes within the dangers that are necessary and obvious. Further, SASA explicitly states that the definition of ski lift includes a tow rope. Plaintiff does not dispute that the metal pole with which plaintiff's decedent collided was part of a tensioning structure associated with the tow rope that was designed to take slack out of the tow rope. The pole was logically a component of the rope tow in question, which is included in the definition of ski lift under SASA. Because the statutory language is clear, judicial construction is not permitted. So the exception would be if something was identified in the statute, but it was not being used for its intended purposes due to lack of adequate signage. That would be an exception. So what if there is something that is not specifically identified in the statute? Does immunity apply to the ski lift or the ski area? And that's where the Anderson test comes in. The court in Anderson versus Pine Knob Ski Resort, it is a 2003 case. Because the legislature, like I discussed earlier, cannot anticipate everything when they're writing a statute. There has to be room for judicial interpretation. And the Anderson test can be used in order to determine whether immunity applies or not. And in the Anderson test, the court created two elements that need to be addressed. The first is the hazard inherent in the sport of skiing? And is the hazard obvious and necessary to the sport? If the answer to those questions are yes, then statutory immunity would apply, even though the hazard is not identified within the statute. The Ski Area Safety Act applies for chairlift injuries, and not only skiing injuries, but it also applies to chairlift injuries. And remember that chairlifts can include tow ropes. If someone were going up the bunny hill, for example, that would be included. And the Ski Area Safety Act does grant broad immunity to ski area injuries involving chairlifts. This immunity provision would apply even if there are claims of negligence on the part of the chairlift operator. So in regular premises liability, a lot of plaintiffs attempt to get around what we have in premises liability is the open and obvious doctrine. In the open and obvious doctrine, the courts have basically said that if a hazard is readily observable by a user upon casual inspection, then the owner of the property does not have a duty to warn of the hazard. And that applies to a premises liability case. And a lot of plaintiff attorneys have been trying to get around the open and obvious doctrine by pleading a general negligence or an active negligence claim against the property owner. Courts have seen this, and they said that if a condition arises out of the land, it's still a premises liability case, and open and obvious could apply if the facts align with that. And in chairlift cases, or even cases that come within the Ski Area Safety Act, a lot of what we're seeing is a lot of plaintiffs are pleading active negligence in order to try to get around the immunity provision of the Ski Area Safety Act. And the courts have generally found that the Ski Area Safety Act applies as it would with the premises liability case. The open and obvious doctrine would apply with the premises liability case if the plaintiff pleads a general negligence claim. And this applies even if there's a general negligence claim that is pled on the part of the chairlift operator. For example, there are a lot of injuries that can arise from someone getting on and off of a chairlift. If you're on a chairlift, a lot of times the injuries can be caused by the person in front of you who either doesn't get off the chairlift in time or trips and falls over the person's skis next to them, which then would delay your ability to get off the chairlift. And sometimes the chairlift operator isn't paying attention and they don't slow down the chairlift, and then a big pileup of skiers ensues before the chairlift operator realizes that they need to stop the chairlift. So if that's the case and the chairlift operator is alleged to be negligent, normally the Ski Area Safety Act immunity provision would still apply. And the case that generally discusses this is Kent versus Alpine Valley Ski Area. It's a 2000 case, and in that case, the court essentially stated that whenever there are children involved, that any lift-carrying children should be equipped with a slow button as well as a stop button. In that case, the plaintiff's expert conceded that the lack of a slow button did not violate B77. Plaintiff's experts pointed to no factual evidence to establish statutory violations by defendants that could affect the otherwise unrestricted immunity for operators when a skier collides with the chairlift. The trouble with tubes. So tubing is not covered by the Ski Area Safety Act. Normally, the Ski Area Safety Act grants broad immunity to ski area injuries involving chairlifts. It does not provide immunity for snow tubing, even though snow tubing may look like skiing or be similar to skiing as it is right now. There is no immunity for snow tubing. So what can a ski area do to protect itself from potential litigation that may arise from a tubing injury? In my opinion, the best defense is always signage, possibly even having a specific area completely designated to tubing alone by roping off the section and having a specific tubing lane where skiers cannot go. Even in the tubing area now, if we do have a separate roped off area for tubing, it needs to be adequately marked with signs. I would definitely ensure that there is a waiver that is signed by the tuber. Possibly also, I would suggest using a haystack or an inflatable barrier to section off the tubing area with signs that may say slow down, stop, do not tube faster than you can control, do not touch other tubers, etc. That would probably be the best defense and the best way to protect yourself in the event that someone is injured during a tubing incident, because immunity would not be granted under the Ski Area Safety Act for a tubing injury since it is not covered. I mentioned with tubing that a waiver would be the best course of defense. The thing about waivers is that they are valid and Michigan courts have upheld them, especially for adults. They are not currently valid as to children. The case on point with adults is Paterick versus 6600 Limited. It is a 1990 case. In that case, a person signed a waiver in exchange for being able to play softball. Obviously, during the softball play, the plaintiff was injured. The plaintiff argued that there was lack of consideration for the waiver. The court disagreed with the plaintiff and found that there was, in fact, consideration for the waiver, and the waiver was valid. The court noted that there was adequate consideration because, 1, it was a legal detriment. Number 2, which induced the plaintiff's promise to release the defendant from liability. And 3, plaintiff's promise to release defendant from liability induced defendant to suffer the detriment. So there was an exchange for consideration. So both sides, both the plaintiff and the defendant, gave up something, and therefore the court found that there was a valid waiver. Waivers signed by parents in order to waive their child's rights, however, are not upheld by the courts in Michigan. The Michigan Court of Appeals case Woodman versus Kara addresses that. It is a 2008 case. And in that case, the child went to a bouncy house where there was an inflatable houses and lots of different fun activities for the kids to play on. The bouncy house required the parent to sign a waiver on behalf of the child. The child was injured while in the course of bouncing on the inflatable structure. And in that case, the court found that a waiver signed by a parent for the child will not be upheld, as a parent cannot waive the rights of a child. And unfortunately, that is the current law in Michigan. Therefore, although waivers for adults are valid, waivers for children are not. As a ski area, however, in defending against this claim, I recommend that you still have the waiver signed by the parent, as it may deter some parents from filing suit if their child is injured. Although it's not upheld in Michigan, it could be persuasive in persuading a jury or a judge that the parent understood the risks and was willing to waive the child's rights. And I think that the older the child is, the better an argument that the ski area has that the waiver should be valid, especially if the child is close to being age of 18. I think that if under direct or cross-examination, if a child testifies that they're close to turning 18 and they understand that this waiver was in place, I think that would be persuasive, although, again, not completely authoritative under Woodman versus Kara, because waivers are not valid for children. So then there are some questions as to whether the Ski Area Safety Act immunity provision is ever going to be dismissed or appealed. And it's my opinion that it is alive and well currently. There is a recent unpublished decision, Marshall versus Boeing, where there was a snowboarder involved in a terrain park. The snowboarder had been doing tricks earlier in the day and went to the half pipe. Later in the day, he came back to the same half pipe, and at that time he was injured. The snowboarder made a claim that the half pipe was not visible, and therefore the Ski Area Safety Act did not apply. The court upheld immunity for the ski area, however, and I think that the court's going to continue upholding immunity for the ski area as long as the ski area follows the signage licensure requirements that are outlined in the Ski Area Safety Act and does what it can to keep the ski area safe. I think reasonable efforts will be looked upon favorably by the courts. In the Marshall versus Boeing case, the court also found that the plaintiff had seen the terrain park earlier and had accepted the risk. We talked about assumption of risk earlier. There are some dangers that are inherent in the sport of skiing, which includes snowboarding, And those dangers are not unnecessary or not obvious sometimes, and therefore they're inherent in the sport, however. And the court said that, just because the plaintiff is claiming that he couldn't see the half pipe the second time around, it was there earlier in the day. He had already visited it, and there's no dispute that the defendant clearly marked that area. Defendant complied with the requirement, and therefore the immunity provision would apply. I don't foresee the immunity provision being overturned anytime soon, although it is important that the signage and licensure requirements are followed by the ski area, and the ski area takes reasonable steps to protect itself. Especially, I do not see the SASA being overturned anytime soon based upon the Anderson case. In the Anderson case, there are the tests that we had discussed earlier. If something is not specifically enumerated in the Act, you must follow the test in order to ensure that immunity would still apply. What takeaways are there from this presentation besides take reasonable efforts to maintain a safe ski area? I would say that the use of statutory immunity should be used in defending ski area claims when a plaintiff is injured in the ski area. I recommend that directed discovery be sent to the plaintiff, as well as ensuring that the plaintiff can prove that there was no signage or proper licensure used by the ski area. I would maybe do requests for admissions to find out what evidence the plaintiff has to support their claims that the Ski Area Safety Act would not apply. It's important also to take away that the Ski Area Safety Act immunity provision applies to not only skiers, but it also applies to snowboarders, chairlift injuries, but it does not apply to tubing. The best defense to tubing injuries are the same as regular premise liability claims. I would say adequate signage, section off the area, make reasonable efforts to keep the area as safe as possible for the participants, and definitely get a waiver regardless of whether it's a child or an adult. Although waivers are not valid for children right now, I would still get them, as it may dissuade some people from making further claims if they know that they signed a waiver. And that's it for the webinar right now. Thank you for attending the use of statutory immunity in defending ski area claims. I am available if anyone has any questions or comments. You may reach me over email at kjoyce@secrestwardle.com, or you can call me at my direct line 248-539-2849. Thank you again.